At any given moment of the day, millions of people all around the world are blogging and disseminating their activities or opinions to followers on Twitter, sharing photographs and other information through Facebook, updating their MySpace accounts with recent news, or engaged in other online activity. Certainly in this room, that would include things like LinkedIn and other activities. The growth of social media has been alarming and has really brought upon, I think, very dramatic changes in litigation. This September, the CEO of Twitter provided the most recent statistics about Twitter during his State of the Union address. There are currently 100 million active users and over 200 million accounts, generating about 230 million tweets per day, and that's up about 110% from just a year ago. More than 120 million professionals covering hundreds of industries are connected through LinkedIn. The 120 million members include executives from every Fortune 500 company. Facebook has more than 800 million active users. And this has obviously had, as many of you know, broad implications through particularly litigation, but also certainly in-house management of employee activities. We're going to focus today on the growth of social media's impact on various aspects of litigation, primarily through the discovery process, which is probably the first area that it became important in. And then as I learned quickly this year, its effect on trials, which are wide-ranging, including through the jury selection process, deliberations, and certainly in terms of finding information about witnesses, adverse witnesses. And finally, the effect on employer-employee relations, which is sort of probably more pressing to the in-house folks here today. That's really sort of an effort to avoid getting to the trial.
Mike likes to talk down about getting to the trial, even though that's how he bills me by the hour, repeatedly.
So, you know, it has important consequences for companies across other areas as well. Companies like the UFC using blogs, Facebook pages, and other similar social media to promote themselves need to be cautious about the content that they're putting out there and need to keep an eye on it. Companies should also be aware that simply because the technology is private or for internal use only, it's not necessarily insulated from discovery. And these issues may not be limited to just company-sponsored content, but could extend to content posted, as we'll discuss later, by employees or clients on their personal sites.
Before we even go on, some of the things that people have to keep in mind is when you start talking about the effects of it in discovery, it starts really with the effects of it in the everyday workplace. There was a recent inquiry from the SEC on a Reg FD issue regarding material non-public information disclosure because an employee of a public company checked in on Foursquare and checked in on Foursquare at the coffee shop on a campus of a competitor where they were in discussions with for an M&A transaction. That led to some speculation about why that person who was in the strategic part of the business was at the premises of a competitor, and it caused trading in the security in an unusual way. These types of access to social media are ingrained in every employee and every person. When you're talking about the number of contacts you have in a given day, we spend more time at work than anywhere else. For us, we can't get our executives to put down their BlackBerry. My wife can't get me to put down my BlackBerry. We are constantly connected, and in that world, trying to manage through employees' use of social media, both from a business and personal perspective, is impossible. You can't limit it. You can try to get your arms around what they're doing and how they're doing it and socialize them. But you get risks that involve well beyond those types of disclosures. You have data security risks, people who are on Facebook and LinkedIn getting contacted by people they think they might know. The next thing, they have information posted about them. They list their personal email accounts. They list their hometown. Start to think about what your email recovery questions are. If you forget your password, what hometown are you from? What kind of car did you have? How many people post that type of information on a Facebook page or a LinkedIn profile? We've had, in my company, employees who've had their emails taken over by other people because their email password recovery questions were discernible. That led to the hacking of their personal accounts, finding of documents that they had emailed themselves so they could read on a train or read at home. And you start to realize that when you get into the discovery of where you have to even look to find this problem, it goes well beyond your own personal corporate records, from a company's perspective to the individual's records, and trying to socialize your employees and, for outside counsel, socialize your clients to the breadth of the issue that you're facing when a litigation comes up is a daunting task.
And certainly as social media grows, it's become a treasure trove of information in a discovery setting. As a former prosecutor, both Seth and I as former prosecutors, there's just so much that you can mine from social media in terms of learning about your adversary, learning about their case, learning about their company, learning about their witnesses. And let me ask now for all in-house, or excuse me, all outside counsel, any litigators, have any of you used social media in terms of just to try to find discovery on adversaries? We've quite a bit. And do we have any interesting anecdotes from those efforts? Anyone want to share something?